name is Dr. Sanjeev Gowda GS. He is assistant professor of law. He has cast the he's the ninth rank in LLB. He secured and did LLM from University of Mysore. He did his MPhil in Judicial Sciences from the Global Open University, New Delhi, and PhD in law from Bangalore University. He has many publications and he has extensive academic and administrative experience of over 18 years. And he also authored some of the study materials on constitutional law and administrative law for LLM program at the Karnataka State Open University. So it's a privilege, sir, to have you here. And I also tell the students that kindly take this opportunity to interact with him if you have any doubts after the classes. And I welcome you on behalf of the university once again, sir.
Thank
And
you, madam.
first to please proceed with the session. And the students kindly mute yourself during the session. After the end of the classroom, you can just raise your queries. Thank you, sir.
Yes,
Thank you,
madam.
all of you.
Thank you. Thank you very much.
Thank you, sir.
Yes, friends, the slide is visible.
Yes, sir.
Yeah. Yes, good afternoon, all. Oh,
Good afternoon, sir.
am I audible?
Yes,
Yes,
sir.
yes,
Yeah,
yes.
am I audible? Okay. Yes, in this couple of days, I'm going to deal with the protection of industrial property at the national level in your program number MP005. So today I'm going to deal with two blocks. One is patent protection in India. Another one is protection of designs and trademarks. Friends, before going to the detailed analysis of the uh, intellectual property, particularly patent, trademark, and designs, let me discuss about the background. I mean, the very meaning of the intellectual property. What are intellectual property? So, because this is the one kind of property, it is protected under the legal regime. So that's what we need to study about what do you mean by intellectual property, because we come across a property that is a physical property, which is where a man can earn, a person can earn, so earn a property. But here, that property, word property is qualified with the intellectual property. What does it mean? It is something produced using human intellect, which has commercial value. That is, where an individual invested his intellectual labor and thereby invented something which is having a commercial value, it is regarded as a intellectual property. Because a mere property, anything fetch a value, it is called as a property. But when we say about the intellectual property, that a property always accompanied with the intellectuality. I mean, emerged out of an intellectual human intellect. So So that's what here intellectual property is something produced using a human intellect, which has a commercial value. Just a commercial value. Because if you want to say a property, there must be a value. Value. That's what here a intellectual property also having a commercial value. It is so-called intellectual property because it is a product of human imagination, creativity, and inventiveness. It is not emerged out of not only emerged out of a physical labor. It is majorly involving in a human imagination, a creativity, and inventiveness. Intellectual property can be seen in the form of intangible assets, intangible creation of the human mind, usually expressed or translated into a tangible form that is assigned certain rights of a property like paper, CD, computer chips, etc. Because a property can be categorized into two. One is a tangible property and intangible property. Tangible property can be seen, touched, and pursued by human touch. So you can feel a tangible property, that is a corporeal property. But intangible property or an incorporeal property you may not see. Example, a goodwill. You are not supposed to touch or pursue by your senses, but it is a property. It is regarded as a property because it is a value. It is a value. So a goodwill is earned by an individual out of his effort, intellectual effort that provides a value, that provides a gain to the inventor or individual. So that's what intellectual property is, an intangible creation of the human mind. So that intangible creation has to be transformed or translated into a tangible form that is assigned certain rights of a property. So as I told you, there is a paper or CD or computer, etc. Then what do you mean by intellectual property rights? Because the phrase intellectual property rights, it is involving a three words. One is intellectual property rights. What we what we know, so far discussed intellectual property. Then what do you mean by intellectual property rights? See, it can be defined as the rights given to a people over the creation of their minds. Usually it gives a creator an exclusive right over the use of his or her creations for a certain period of time, because a right is an interest created in the given asset that has to be protected by the law. That's what here, if an individual invented something by using his intellectual mind, and that has to be transformed into a physical form, and that will become an intellectual property, then mere creation of a property, it is not suffice. There must be some protection under the given legal regime by granting the rights. So that's what we can see, that intellectual property rights here, usually that right is given to the creator, an exclusive right is given to the creator over use of his or creation for a definite period of time. Here, intellectual property right, it is not to be confused with the IP, intellectual property, because it is a right vested in the asset, not the asset itself. Asset itself. So that's what intellectual property and intellectual property rights are differ. Rights are differ. For example, an individual having an idea or he has invented, it is he has an invention, it is called as an intellectual property. An idea is an intellectual property. So when that idea has been transformed into some other material object and get registration in the given legal regime, it is called as an intellectual property rights. It is become IPR. Or a customer list or a price list, it is IP. A right of confidentiality is an IPR. IPR. So likewise, there are a property is a mere idea itself is not protected. That idea has to be, or invention has to be registered in the given system, then you can get a rights over the such property. Then why do we need to protect the intellectual property? What is the use of the protection of intellectual property? Here, one of the major rationale between the protection of intellectual property, it encourages innovation. The legal protection of new creations encourages the commitment of additional resources for the further innovation, because definitely it will support the people or researcher to invent. It's a new thing. So where we can protect a invention into the legal system, definitely the people are working further. So and they are searching something which is new, novel, and thereby they will contribute to the development of the society. So that's what here, in order to encourage us the innovation, there must be a protection of intellectual property by the law of the land. By the law of the land. Another one, so it provides economic growth. The promotions and protection of intellectual property, definitely it leads economic growth. It creates a new jobs, industries, and enhance the quality and enjoyment of life. Because where there is a new product or a new process is invented by an individual, definitely that will create many jobs, and it will create many industries. Definitely, so that will contribute to the economic development of the country. So that is the another reason we are going to extend a legal protection to the intellectual property, because it contributes to the economic growth of the country. Then safeguards the rights of the creator. Intellectual property is required to safeguard the creators and the other producers of their intellectual commodity, goods, and services by granting them certain time limited rights to control the use made of the manufactured goods. Because once a person or inventor got registered under the legal system, then he will get an exclusive rights, a monopolistic rights over that property for limited period. During that limited period, he is an exclusive right over the others. So one should not make use of that property without his or permissions. So that's what here protection of intellectual property must be needed now to safeguard the rights of the creators, rights of the inventors. So one more rationale behind the protection of intellectual property, that is, it facilitates the transfer of technology in the form of assignment. So definitely here where intellectual properties are protected, then there is a lot of transfer of technology in the form of assignments and transfer to one person to another person. So there is an exchange of knowledge. There's an exchange of knowledge. So that's what we are going to protect the intellectual property. So these are the major idea behind bringing the intellectual property under the legal regime, thereby extending the protection to the intellectual property. Friends, intellectual property, the protection of intellectual property, it is not limited to the national level or domestic affairs. It's not a matter of domestic affair. It is a matter of international affairs. Because so there is a lot of transfer of technologies or inventions across the border. So that's what, in order to protect the intellectual property even beyond the territorial limitations, there must be some protection at the global level. So that's what here we have many conventions and agreement at the global level to extend the protection to the intellectual property. Mentioning Paris Convention 1883, it is for the protection of industrial property. So for the first time at the international level, the Paris Convention was concluded in the year of 1883 in order to extend the protection to the industrial property. Industrial property means a subset of intellectual property. So that has to be protected by the Paris Convention at the international regime. First step to ensure the protection of intellectual work of a people, which covered patents, trademarks, and industrial designs, because mentioning these properties, intellectual properties are a industrial property. There is a patent, trademarks, and industrial designs, and some other industrial properties are there. Then realized the need for international protection of intellectual property. because at the international level, once an inventor invented a new thing, or once a person registered as a trademark for his business, or if there is any industrial design, then that must be protected across the globe. So, in order to protect their intellectual property, there is a international legal regime called Paris Convention 1883. Then one more convention after a couple of years at the international level, that is a Bern Convention for the protection of literary and artistic work. That is other than the industrial property, literary and artistic works, which deals with the protection of works and rights of the authors. Both the treaties are administered by the World Intellectual Property Organization, because we have a WIPO, World Intellectual Property Organization. This organization is administering these Paris Conventions and Bern Convention. So, for the protection of industrial property is concerned, there is a Paris Convention 1883 at the international level. Then, for the protection of literary and artistic work, there is a Bern Convention 1886 at the international level. There's a one more agreement concluded by the members country concerning the international registration of marks, which talks about particularly the registration of the trademarks. It is a one-stop solution for the registering and managing the mark worldwide. File one application in one language and pay one set of fees to protect the mark in the territorial jurisdiction. So manage portfolios of marks through one centralized system. It has provided by the Madrid Convention 1891. Friends, as I mentioned, there is a one more organization called World Intellectual Property Organization, 1967. It is a modern day international body dealing with the regulation of intellectual property. It became a formal part of the United Nations system in the year of 1974. The major focus of the World Intellectual Property, it is establishment and development of the best intellectual property standards. Then the development of a balanced and effective international intellectual property system that enables innovation and creativity for the benefit of all. So that is the main motto behind the World Intellectual Property Organization 1967. Friends, there is a one more a treaty called Patent Cooperative Treaty 1970. It is the international treaty with the more than 150 contracting parties. It makes it possible to seek a patent protection for an invention simultaneously in each of the large number of countries by filing an international patent application, because a PCT, popularly known as a PCT, that is a Patent Cooperation Treaty, provides filing mechanism for a global protection of innovative products and services. That is one of the solution provided to the inventor at the global level by providing a protection at the international level. Then one more very popular international agreement, that is agreement on trade related aspect of intellectual property, that is TRIPS agreement 1995. Friends, it is a most comprehensive multilateral agreement on intellectual property. This TRIPS agreement introduced intellectual property law into the multilateral trading system for the first time and remains the most comprehensive multilateral agreement on intellectual property till today, which covers copyrights, trademarks, geographical indications, industrial designs, patents, plant varieties, layout designs of integrated circuits, and disclosed information like trade secret. So all sort of intellectual properties are covered by agreement on trade related aspects of intellectual property in the year of 1995. Friends, this is the background about the international, I mean the intellectual property rights, and the international legal regime with regard to protection of intellectual property. So let us move on to the national level protection available to the intellectual protection of intellectual property. Before going to that, intellectual property can be categorized into two. One is industrial property and copyright and related rights. Industrial property, as I told you, it is a subset of intellectual property. It is involving, I mean, industrial property comprises patents, trademarks, industrial designs, geographical indications. Then other set of property called copyright and related rights. It is a non-industrial property. Copyright and related rights are a non-industrial property. So let us move on to the legislation governing the intellectual property in India. In India. So what are the legislation passed by the Indian Parliament to extend the protection to the intellectual property within the country? So one of the legislation called Patent Act 1970. So it is a post-independent and post-constitutional law which enacted by the Indian Parliament in the year of 1970 to protect the patent, to extend the protection to the patent patents. Here, so this act was amended in the year of 1999, 2002, and 2005 to meet its obligations under the TRIPS agreement. Because time and again, after 1995, the TRIPS agreement a TRIP agreement requested all the signatory of the agreement to bring certain amendment to their domestic laws in the line of the international trade related aspects of intellectual property agreement. Accordingly, the Indian Parliament time and again bringing an amendment to the Patent Act 1970 in the year of 1999, 2002, 2005 in order to strengthen the production of a patent in India. Then the third amendment brought by the Parliament, brought to the Act in the year of 2005 by the Parliament, it has major implication is that introduction of the product patent. Product, here, well before 2005, there was a protection of a process patent, but in the year of 2005, the Parliament introduces protection of product patent. So, especially for the protection of food, pharmaceutical, and chemical inventions. So, it is a protected under the a present Indian legal regime called Patent Act 1970. Then it provides the provision for the examination, the mailbox application from Jan 1st, 2005. Accordingly, in India, at present, there is a production of process patent and product patent. Friends, there is a one more legislation called Trademarks Act 1999. The Indian Trademark Act has repealed Indian Merchandise Marks Act 1958. This act provides for the procedure of registration of the trademark. It also provides provides for the remedies for infringement of trademark. It also consists of an appellate board, its powers and functions. Because how to protect the trademark, how to register the trademark, and what are the remedies in case of if anybody, any person interferes with the enjoyment of that exclusive right of trademark, what are the remedies available in the legal system? It is provided by the Act of 1999, that is Trademark Act. Then one more legislation called Designs Act 2000. Its main objective is to protect new or original designs from getting copied, which causes a loss to the proprietor. Because here, design protection is very much important in order to protect the proprietor copying from someone else. It is provided by the Designs Act 2000. This act provides a registration of the act, then yes, registration of the act. Then there is one more legislation, the geographical indications of the goods, registration and protection Act 1999. This act seeks to provide for the registration and better protection of intellectual indications relating to goods in India. This act would be administered by the Controller General of Patents, Designs and Trademarks, who is the registrar of the geographical indications. So here it is one more legislations which protects in the intellectual property for the a group of individuals where geographical indications of goods, what we call as a geographical indications of goods act. Friends, other intellectual property right, that is Copyright Act 1957. This has been amended in the year of 1983, 84, 92, 94, 99, and 2012 to meet the national and international requirements. So 2012 amendments make Indian copyright law compliance with the Internet treaties, that is World Intellectual Property Copyright Treaty, and World Intellectual Property Organization Performance and Phonograms Treaty. Then there is a one more legislation, Indian legislation, that is Protection of Plant Varieties and Farmers' Rights Act 2001. So, in order to provide for the establishment of effective system for the protection of plant varieties, the rights of the farmers and the plant breeders, and to encourage the development of new varieties of plants, it has been considered necessary to recognize and to protect the rights of the farmers in respect of their contributions made at any time in conserving, improving, and making available plant genetic resources for the development of new plant varieties. So that is the one more legislation called Protection of Plant Varieties and Farmers' Rights, which extend the protection to the rights of the farmers in respect of their contribution made at any time in conservation and improving and making of a plant genetic resources for the development of the new plant varieties. Friends, I'm audible. Are you following? Hello.
Yes, sir.
Yes, sir, you're audible, sir.
Yeah.
Sir, your slides are not moving, I think. What I feel.
It's not visible.
Yeah. No, visible. Legislation covering IP rights.
Is it visible? No?
Yeah, it's visible, sir.
Yeah, yeah.
Can you put slides on presentation mode, sir?
Pardon?
Can
Slides
you
on
put your
present.
slide on presentation mode?
Yeah.
You can click F5.
एक minute, एक minute. Is it now in presentation mode?
Uh, it's okay, sir. You
Yes.
continue. No problem.
Okay.
Continue.
Yeah. One more legislation called Biological Diversity Act 2002, which is enacted by the Parliament in order to protect and preserve the biological diversity in India. It provides a mechanism for the equitable sharing of benefits arising out of the use of traditional biological resources and knowledge in our country. So this is the one of the significant law made by the Parliament, that is Biodiversity Act 2002, to extend protection to the biological diversity of the country. I mean, traditional biological resources of our country. Friends, apart from these national legislation passed by the Parliament time and again to extend the protection to the intellectual property, there is a IPR policy, National Intellectual Property Policy, uh, passed by the come out by the state, I mean central government, that is called as a National Intellectual Property Rights Policy 2016, which was adopted in the year of in May, in the month of May 2016, as a vision document to guide future development of IPRs in the country. It is called Creative India and Innovative India. It encompasses and brings to a single platform all intellectual property, taking into account all interlinkages, and thus aims to create and exploit synergies between all forms of intellectual property concerning statute and agency, because this is the policy which boosts the inventors and industries to protect the intellectual properties. It sets a place an institutional mechanism for implementation of monitoring and review, which aims to incorporate and adopt a global best practices to the Indian scenario. Then another policy point, Department of Industrial Policy and Promotion, Ministry of Commerce, Government of India has been appointed as the nodal department to coordinate, guide, and oversee the implementation and future development of the IPRs in India. Then another point of national IPR policy, establishment of the cell for IPR promotions and management under the aegis of DIPP is to be the single point of reference for the implementation of objectives of the national IPR policy. Then India's IPR regime is in compliance with the WTO's agreement, World Trade Organization agreement on related aspects of intellectual property rights. Because always the national policies and national legislations and policies are it should be amended and formulated in the line of the WTO's TRIPS agreement. Friends, let us move on to the Patent Act, patents under the Patent Act 1970. What do you mean by patent? And so, what are the patentable inventions and what are the non-patentable inventions? How to obtain the patent? That is, what is the procedure provided under the Act to obtain a patent? And is there any opposition for the grant of patent? And so, what are the rights of the patentee? And so, is there any remedy available under the legal system for the uh, infringement of the patent rights? These are the things we need to study in this session. Patents. Patent is an exclusive right. It is granted by the authority to the applicant of an invention for a limited period of time in lieu of a full disclosure of invention. So, a patent is nothing but an exclusive right, a monopolistic right granted by the government to the inventor for a stipulated period of time in lieu of, in return of full disclosure of his invention. So, if an individual discloses his invention completely, then thereby he will get a right, exclusive right by the competent authority for his invention. So that is called as a patent. So patent is nothing but a monopolistic right given to an individual by the government for his invention. Then, so remember, a patent is granted for an invention. Then, what do you mean by invention? Whether all the inventions are comes under the Patent Act 1970, because patent is granted for an invention. Then, what do you mean by invention? Here, invention means any product or a process which is new, novel. Friends, keep in your mind a product or a process which is new or novel. Already I told you here. So now the Patent Act 1970 extend the protection to the both process patent and product patent after 2005. So that here, Patent Act grants a patent for an invention by an individual. That invention must be, if that invention is a product or process, but it must be qualified with a novel, new. It should not be existed earlier. It should not be in the public domain, already known to the people at large. It should be a invention. It is a new, not known to the public at large, not known to the people. So that is the one a criteria need to be fulfilled for the invention. I mean, to qualify a process or a product as an invention, it must be new. Second criteria, that is involving an inventive step, non-obviousness, utility. So that is there must be inventive steps. There is a clarity in the invention. There is a clarity in the invention. There is no any ambiguity. There is no any ambiguity in the process or in the product where an individual invented a new product or process. It should involve an inventive step. It is qualified with the non-obviousness, and it should explain about its utility. And it must be capable of industrial application. Any invention must have a capable of industrial applications, because without industrial application, if you are going to invent something, then if you get an exclusive right over that a property, that invention, then there is no any capable of industrial applications. Definitely, it's of no use. So that's what each and every invention must have an industrial application. Then only it will encourage the further research, further invention, and it will encourages for the economic growth. So that's what here a patent is granted for an invention. Invention means product or a process which is a new or a novel involving an inventive step and are capable of industrial applications. So because a patent must have an industrial application, then there is a lot of a benefit given to the inventor by for 20 years, because here the patent once granted by the competent authority, then the patentee or inventor, so he can enjoy that a patented rights exclusively for the period of 20 years. So that's what in a 20 years he can reap the benefits by uh, applying for industrial application. I mean, by applying the patent for industrial application. Then patent is a territorial right. An Indian patent cannot be enforced outside India. To obtain a patent protection in different countries, each country must apply for a patent. The Patent Cooperation Treaty provides a way to file an international patent application in which a patent can be filed through a single patent application in large number of countries. There is nothing like a global patent or a world patent. Because the Patent Act 1970, it is a territorial laws. Under the Patent Act 1970, if an inventor granted a patent and thereby he has to use that patented product or a process within the territorial limitation of India, not beyond the country. If he want to extend a protection to his invention even beyond the Indian political territory, then he must and apply a patent in individual country. Or now there is a provision PCT, Patent Cooperative Treaty. Here, once the person applied a patent under the cooperative treaty, then there is an protection of patent in larger number of countries. That is a patent PCT system is there. Then what do you mean by patentable and non-patentable invention in India? Patentable, already I explained, patentability requirement in India is invention. It should be novel, inventive, and capable of industrial application. So where an individual process or a product qualify these three criteria, it is patentable in India under the Patent Act 1970. So what about the non-patentable? Because there are many invention, it is not patentable in the public interest or public health or the law and morality. We are going to prevent not to grant a patent to the some inventions. Section 3 and 4 of the Indian Patent Act 1970. This act has a long list of area which are not covered under the patentability in India. Invention that is frivolous or that claims anything obviously contrary to well-established natural law. If any individual invented something which is frivolous, which is false, that claims anything obviously contrary to the well-established natural law. So, if anybody invented anything contrary to the established natural law, definitely it is not patentable. Not patentable. That invention is not patentable. Then an invention, the primary or intended use of which would be contrary to the law, morality, or injurious to public health. If anybody invented anything which is injurious to the public health or against the morality, against the law of the land, definitely that is not protected under the Patent Act by granting a patent. A mere discovery of scientific principle or the formulation of an abstract theory, it is not patentable. So a mere abstract formula, it is not patentable. It is not patentable. There must be a clear description about the invention. An abstract theory is not patentable. Then a mere discovery of a new property or new use for a known substance or the mere use of a known process, machine or apparatus, unless such known process results in a new product or employs at least one new reactant. So here, a mere discovery of a new property or new use for a known substance is not patentable, because a discovery is not equivalent with the invention. Discoveries already exist in the system. We are going to search and discover the thing. But invention, which is not known, which is not exist in the system, we are inventing new thing. So then it is a patentable. So that's what here, mere discovery of a new property, it is not a patentable under the Indian Patent Act. Friends, one more. A substance obtained by mere admixture resulting only in the aggregations of the properties of the component thereof or a process for producing substance, it is not patentable. That is a mixture of two or more components and thereby produces some a product, then it is not patentable. The mere arrangement or a rearrangement or a duplication of a known devices, it is not patentable. A method of agriculture or horticulture invention relating to atomic energy within this enactment, it is not patentable. Any process for medicinal, surgical, curative process, any process for medicinal, surgical, curative, or treatment of human beings or animals, it is not patentable. The other plants and animals in whole or any part thereof, other than the microorganism, but including seeds, varieties, and species, and essentially a biological process for the production or propagation of plants and animals, mathematical or a business method or a computer program per se or algorithms are not patentable. Then mere scheme or a rule or a method of performing a mental act or playing game, it is not patentable. Playing game or a mental act of an individual perform, it is not patentable. Then what is the procedure for grant of patent? Here in India, under the Act of 1970, there is a patent administration. A patent here, the Act provides a four officers across the country in order to make an application before them and thereby gets a grant of patent. A patent application can be filed at any of the four patent office in India. One is Kolkata, it is the head office, Mumbai, Delhi, and Chennai. We have a four patent office across the country. So southern states are comes under the Chennai, and likewise all the states are allocated to the four branches of the uh, country. That is the patent administration provided four branches. That is Kolkata, Mumbai, Delhi, and Chennai. Then who can apply for a patent? A true and first inventor. Because as I told you, I have an idea, then that idea must be protected as an intellectual property means, then I'm a true owner. I'm a first inventor. So I have every right to apply for grant of patent. So that's what here a true and first inventor who holds the rightful ownership in the invention. So he is a competent person to apply for grant of patent before the appropriate authority. Then, apart from true and first inventor, a person who is an assignee or a legal representative of a first and true owner. If the true owner or a first inventor, so assign is right to the someone else or is legal representatives, they may apply for the grant of patent. Then the third category, legal heirs of the first and true inventor in case of demise of the true and first inventor. So a true inventor or a first inventor invented something. If he dies, so after his demise, his legal heirs are the first and true inventors for the purpose of applying for the grant of patent. So these are the three categories: a true and first inventor, a person who is an assignee or a legal representative, a legal heirs of the first and true inventor in case of demise of the true and the first inventor. Then, what are the stages of the, uh, in production of a patent? Here, the patent application passes through these stages. One is filing of an application. That is a very much important. It's the first stage, filing of an application before the authority. Then the application must be published in the journal, that is IPR journal. Then there is an examination of such application by the authority. Then, so inviting any opposition for the grant of patent, maybe a pre-grant opposition and post-grant opposition. So after that, there's a grant of patent. So these are the stages I come across by an individual to get a patent: filing of an application, publication of the application, examination, opposition, grant. Then procedure is that filing a patent application along with the required documents. Publication of the patent application, that is 18 months publications. Filing a request for examination. Filing a pre-grant opposition by an interested person, examination of the patent application based on the turn of request for the examination, filing reply to comply with the requirements of the objections raised by the patent office, attending hearings if any, acceptance or rejection of the patent application, publication, grant of the patent application, then filing a post-grant opposition by an interested person, then the grant of patent. These are the procedure available under the Indian Patent Act along with the Indian patent rules framed by the government. Then, what are the documents required to file a patent application? Of course, form number one is the application form provided in the rules. There is a specification. Form number two, here the inventor, a true inventor must provide a specification about his invention. Invention. So there is a provisional specification and a complete specification. In the coming slides, I will explain specification. Then, along with the application, he has to provide some drawings if needed to describe the invention clearly and sufficiently. Then, undertaking under the Section 8 of the Act, declaration of inventorship, then document to claim priority. In case of conventional application, priority date must be claimed. Then, power of authority if the patent application is filed through a patent attorney. So it has these are the documents required to attach it to the patent application. So here, once the application is filed with the patent office for the grant of patent, every application shall be published after the expiry of 18 months from the date of filing or date of priority of the application, except the following situation like application in which secrecy direction is imposed or has been withdrawn before 3 months prior to expiry of 18 months. However, the applicant can make request for early publication prior to 18 months on Form 9 with prescribed fee of 2005 or 10,000 rupees by individual or legal entity respectively because fees may be vary according to the changing circumstances. So after having filing an application for the grant of patent, there's a publication of such application. So here from every application shall be published after the expiry of 18 months. So 18 months after expiry of the 18 months, the a patent office going to publish the application. Publish the application. Even well before 18 months, the applicant may request the publication of the uh, application. So there is a provision. Then another one, filing request for examination. A request for examination can be filed in the Form 19 only within 48 months from the priority date or filing date, whichever is earlier. So it is another time period prescribed for the examination. A request for examination can be filed in the Form 9 only within 48 months from the priority date or filing date, which is earlier, if you want to examine the patent. Specification. So let us move on to the patent specification. There are two kinds of specification. One is provisional and complete specification. Friends, each and every application must be accompanied with the specification, as I told you earlier. Provisional specification, which comprises title of the invention. Title of the invention. Little title has to be provided in the application. Then a written description regarding the invention. A brief written description regarding the invention you have to be provided. Then a drawings of the invention if it is necessary. If your invention demands, then you have to provide a drawings about that invention. Then sample or a model if required. If it is a product, you have to provide a sample or a model if it is required. So these are the things provided in the provisional specification. So while making an application uh, for a grant of patent, so you have to submit a provisional specification. These are the description. Because what are the advantage of the provisional specification? Friends, here priority for invention. In order to claim the priority date, so we are going to file a application along with the provisional specification. So in order to claim the priority date, then 18 months, well before. Meanwhile, nobody has to make an application about the same invention. So that's what, in order to claim a seniority, we are going to file an application along with the provisional specification. Then another advantage of the provisional specification to get extra time for further development, because 18 months use time is available for the inventor to invent something. Work on it uh, to get the to get the patent. Extra time available for the further development. Then disclose to interested person to obtain a financial support. Explore commercial feasibility. Commercial feasibility before going to grant patent. So you may explore the commercial utility of the and, a future patent. So that is the advantages available after the submission of the provisional specification. Then avoid further expenses if no commercial feasibilities. If the inventor comes to know that if I get a patent for such invention, if there is no any commercial feasibility, there is then it's of no use to continue the work on it. So that's what a provisional specification provides. And these are the advantages. Friends, complete specification. What do you mean by complete specification? Complete specification mainly relied upon description and claims. Description and claims. Description talks about the technology section. Claims talks about the legal section. Description means in a complete specification, title of the invention, field and background of the invention, use of the invention, prior art in the said field of invention and its drawbacks, then comparison between the prior art and present invention, object of the present invention, summary of the present invention, statement of the invention, detailed description of the invention with respect to drawings, if any, working example for the best method of invention. So here there's a detailed specification provided by the inventor in complete specification, detailed description. So about the invention. Then after providing a detailed description, then there's a claim section that is key to all patents, protect legal rights of the patentee, defines the legal boundaries of the granted exclusive rights, determines exactly what the pet inventor is entitled to exploit commercially, and exclude others from practicing, making, using, selling, importing, and are offering for sale. So that is the and here we are going to exactly determine the actual right of the patentee after the submission of the complete specification. So once the a true inventor file an application before the patent office for the grant of patent, along with the provisional specifications or a complete specification. So there is a provision for the grounds of opposition. Grounds of opposition. Here there is a pre-grant opposition and post-grant opposition is provided by the enactment. The grounds on which the opposition can be filed are provided under Section 25 of the Patents Act 1970. 1970. So, where an invention wrongfully obtained under Section 25A, invention has been published before the priority date of the claim, prior claim, invention publicly known or publicly used, obviousness and lack of inventive step, not an inventive or not patentable, insufficiency of description, because these are the grounds available to an individual to challenge the grant of patent, non-disclosure of the information, time-barred application, non-disclosure of the source of biological material, invention anticipated by the local knowledge. So these are the grounds available to an individual to prevent a grant of patent by making a opposition. So as I told you, there is a two kinds of opposition. One is a pre-grant opposition and post-grant opposition. Pre-grant opposition, section 25, subsection 1 says that upon publication but before grant of patent. Because a pre-grant opposition we are talking about after the publication of a patent application, but before going to grant a patent because there's sufficient time. So here, during that time, any person based on different grounds may file a pre-grant opposition in writing, represent by way of opposition to the controller against the grant of patent. However, the opposition will be taken by the patent office only after filing of request for examination. Keep in mind, Apposition will be taken by the patent office only after the filing of request for examination. So that is the one condition. Then, is there any time limit for the opposition? Yes, may be filed within 3 months from the date of publication of the application, or before the grant of patent, whichever is later, within 3 months from the date of publication of the application, or before grant of patent, whichever is later. So here in the form 7A of the patent rule, along with the representation, comprises the statement regarding opposition, evidence regarding opposition, if any, request for hearing. It is an optional. So we have to provide this information in a pre-grant application, opposition application. Then an application can go for an appeal against the decision of the controller. Such an appeal can be filed in the intellectual property board earlier, because here, in the year of 2021, the government of India abolishes the many tribunals, including Intellectual Property Appellate Tribunal (IPAB). Now, whatever the order passed by the controller, so against the order of the controller, you can prefer an appeal to the High Court directly. So there is no any Intellectual Property Appellate Board now. So to hear the appeal from the orders of the controller. So of course, a controller is the first a competent authority to receive a grant of opposition for the grant of patent. Then there's one more post grant opposition, section 25, subsection 2, which talks about the post grant opposition. Upon grant of patent, may any interested person, based on different grounds, may file a post grant opposition in the form submitted to the controller against the grant of patent. Time limit is within 1 year after the grant of patent. Keep in your mind. So where a patent is granted to an individual, then after the patent has been granted to an individual, if you want to challenge that grant of patent, you have to make an application to the controller within 1 year from the date of grant of patent, not beyond that. Then in that post-grant opposition form and content, the notice of opposition shall be in the form number 7, written statement setting out nature of the interest, evidence regarding opposition, statutory fees, request for hearing. So each and everything is provided in the post-grant opposition. So likewise, here interested person may oppose the grant of patent at both pre-grant and post-grant. So once the opposition is heard and decided, there is a next process is that grant of patent. Because if there is an opposition, then the opposition is heard that there is no such kind of prove where the applicant failed to prove the opposition, then the authority is going to grant a patent and sealing of patent. So a patent will be granted to the applicant if the applicant has compiled with the objections within the prescribed time. No pre-grant opposition by representation is filed. If filed, disposed of in favor of the applicant within the prescribed time. Then patent will be granted and sealed with seal of office and notified in the official journal. The patent so granted shall be sealed with a seal of patent office and the date. Then once the patent is granted to an individual by the government, then what are the rights available to the patentee? Patentee. So here, as per section 48 of the Patent Act 1970, there are four exclusive rights available to the patentee after grant of patent. Here, patentee used to exploit the patent exclusively, because a patent grants exclusive right to exploit the invention by the inventor. Now it's a patentee. So, right to exploit the patent, it is one of the right available to the patentee after the grant of patent. Then right to grant license. He himself is not able to exploit the patent. He may allow someone else by issuing a license to make use to exploit the patented invention. invention. So that means a patentee has a right to grant a license to an individual to exploit the patented invention. Then right to surrender. If you are not able to exploit, then you may surrender the granted right or granted patent to the concerned authority. Then one more, right to bring an action for the infringement, right to sue for an infringement, because it is an exclusive right. It's a monopolistic right available to the patentee. Patentee always exclude the others for 20 years. For 20 years. So if any individual infringes that patented invention, so making use of that patented invention, so definitely it amounts to infringement, unlawful interference of the patented rights. Then here the patentee or his assignee, they may bring an action against the such infringer by filing a suit. That is a right to sue for infringement. So that means there are four kinds of rights: right to exploit the patent, right to grant license, right to surrender, right to sue for infringement. Then, is there any transfer of patent once obtained? Yes, a patent is an exclusive property of the inventor, and hence it can be transferred from original patentee to it can be transferred to original patentee to any other person by way of assignment, grant of license, or by operation of law. These are the three modes available to transfer the patent. One is assignment, grant of license, or operation of law. So here, intellectual property assignment requires that license or a creation of any other interest in a patent must be in writing, clearly specifying all the terms and conditions governing the uh, rights and obligations of the parties. So, friends, here assignment must be in writing. Assignment must be in writing. It must be clearly specifying all the terms and conditions governing the rights and obligations. Because it's a property. It's a property. If you want to assign any property, so what are the conditions? What are the mode to assign? Obviously, it should be in writing and clearly specify all the terms and conditions of the governing the rights and obligations of the parties. Then one more, the document must be registered in the prescribed manner within the prescribed time. So if it is assigned, grant of license, or transferred by way of operation of law, whatever may be, so it must be in writing and clearly specifying the terms and conditions, and it must be registered in the prescribed manner within the prescribed time. So these are the things about rights of patentee and transfer of patent. Then is there any limitations on patentee's right? Once the patentee obtain a patent, and he will have an exclusive rights. So whether that right is an absolute right, or is there any restrictions or limitations on exploitation of the patentee, patented invention? Yes, here the Act provides certain limitations on the exercise of rights. There are government use of patent. It is an exception to the patentee's rights. Government use of patent. Compulsory licenses, use of invention for defense purposes, revocation for non-working of patents, restored patents. These are the five limitation and part of the exercise of exclusive right of an individual. Here, it is pertinent to discuss about the compulsory licenses. A patent holder may refuse to grant a license on his invention. However, in some cases, this choice is withdrawn and they must tolerate a compulsory license granted by the public authority and in government. Such licenses are not exclusive and are subject to the financial compensation. Financial compensation. In addition, they will only be granted if a voluntary license was requested from the patent holder and refused by the latter. Refused by the latter. Here, the government may issue a compulsory license to the license on the invention of a patentee in order to exploit it. So by extending the some monetary compensation without his consent, without his permission, definitely yeah, the government, central government having a power to issue a license to exploit the patented invention. So here it is possible to apply for a compulsory license in the certain circumstances. One is in the event of non-exploitation of invention. So sometimes the inventor he may not exploit the patent invented, patented invention for so many years, definitely the government has ever a right to issue a compulsory license to an individual to make use of that patented invention by extending certain monetary or financial compensation to the inventor. So, in the event of non-exploitation of invention, here the government is going to issue a compulsory license. In the event of invention for which exploitation depends upon another invention, and another one in the event of a public health problem, these are the circumstances exist or demands to issue a compulsory license on the patented invention. Friends, another one, infringement of patents and remedies. Infringement of the patents and what are the remedies available for the infringement. So, patent infringement is nothing but making, using, offering for sale, selling, or importing for these purposes the product or process in India without the permission of the patentee. It amounts to patent infringement. So, there are two kinds of patent infringement. One is direct infringement, another is indirect infringement. So here, uh, for the patent infringement, there is an exception. Use of invention, because all making, using, offering or importing something for some other purposes may not comes under the patent infringement. So that's what there's an exception. Use of invention for experiment or research or instructing pupils, it is not an infringement. It's not an infringement. That means an institution or an individual making use of the patented invention for experimental purposes or for research purposes or for giving information or instruction to the student at large, then it is not at all an infringement. It is not at all an infringement. Then, where the government use, as per Section 100 of the Act, a patented invention can be used. It can be used by the central government for its own use, and as per Section 47, the patented invention can be imported by the government. By the government. Then exemption on the experiments and research, as I told earlier. Then patented invention on drugs and medicine can be imported by the government. So a patented invention on a foreign vessel, aircraft, vehicle comes to India is not an infringement. So these are the exception to the patent infringement. Then, so where to file a suit for the infringement? Who has a power to file a suit? So here, suit for infringement, a right to sue for infringement belongs to the patent. Of course, patentee is a person who is enjoying an absolute right, I mean the exclusive right over the patented invention. If anybody interferes with the enjoyment of such exclusive right of patentee, definitely he has a very right to bring an action against the person who has infringed. Then, other than the patentee, is assignee. Is assignee. If he has assigned his right to someone else, then that person become an assignee. He is also a competent authority or entitled to file a suit against the infringement, or a co-owner, where there is a joint grant of patent, then a co-owner may also bring a suit for the infringement. So these are the two category of people may bring bring to the knowledge of the court with regard to infringement of patent. Then, so where to file? Section 104 of the Patent Act 1970, which deals with the filing of the suit by the patentee against the infringement. The patentee can file a suit in a district court or directly in the High Court under Section 104 of the Patent Act 1970. So keep in your mind, friends, here, so jurisdiction to file a suit for the infringement, district court in a district is a competent authority, or High Court in a state is a competent authority to admit a case not below district court or not below High Court. So, concurrent jurisdictions available in district court and High Court directly. A patentee can, or a assignee or a co-owner can file a case. According to Section 19 of the, apart from this, Section 19 of the Civil Procedure Code, the patentee can bring the suit for infringement in the court which has jurisdiction in area where he or she resides or carries on a business or a personally work for gain. That is another a provision created in the legal system to file a case. Then on whom the burden of proof lies? Section 104A of the Patent Act deals with the burden of proof. Generally, in case of infringement, the burden of proof is on the plaintiff, because one who invoke the jurisdiction of the court of law by filing a suit for the infringement, definitely the burden of proof lies on him. He has to prove the infringement. Then sometimes the burden of proof keeps on shifting to the opposition. Next one. So infringement of patents and remedy here. Sorry, suit for infringement. Then limitation. Indian Limitations Act governs the period of limitation for bringing a suit for infringement of patent, which is for 3 years from the date of infringement. Because so 1 year the limitation period is imposed on part of the a person if a assignee or a patentee or co-owner wants to file a case for the infringement of their patents, definitely they have to invoke the jurisdiction of the court of law within 3 years from the date of infringement. That is the limitation period imposed so under the act. Then what are the remedies available for the infringement? Section 108 of the Indian Patent Act provides a certain remedy, specific remedy to the uh, patentee for the infringement. One is permanent injunction. So he may seek the permanent injunction against the infringer, temporary or interlocutory injunction, or ex parte injunction. Damages are on account of profits. You may seek the damages are on account of profits out of the Defendants Act. Then seizure, forfeiture, or destruction of infringing patents, goods, and or materials. This is the another remedy available to the plaintiff: seizure, forfeiture, or destruction of the infringing products, goods, or materials. So these are the specific remedy available under the section 108 of the Indian Patent Act for the suit for infringement by the patentee. So, friends, I need to discuss about a little about the Novartis versus Union of India 2013 with regard to patent invention. Here, in this case, there is a rejection of patent for drug which was not inventive or had an superior efficacy. Here, the Novartis filed an application to patent one of its drugs called Glovec by covering it under the word invention mentioned in Section 3 of the Patent Act 1970. Because here the Novartis added something to the existing patent and thereby they apply a patent for evergreen. The Supreme Court of India, I mean the controller of the patent, rejected that it is not an invention. Adding something to the existing things, it is not patentable under Section 3 of the Act. So the Supreme Court rejected their application after 7 years of long battle by giving the reasons. A mere discovery of an existing drug would not amount to invention. The mere discovery of an existing drug would not amount to invention by adding something to the existing one or by improvising something to the existing drug. Thereby, they are going to claim a exclusive right. It is not available because a mere discovery of an existing drug would not amount to invention. Then the Novartis drug did not qualify a new test of enhanced therapeutic efficacy for claims that cover incremental changes to existing drugs. So this is the one of the landmark judgment with regard to patent in India. Friends, there are some certain offences and penalties also provided by the Act. One is with regard to contravention of provisions relating to certain invention, imprisonment up to 2 years or a fine or both. Then falsification of entries and register, etc. Imprisonment up to 2 years or fine or both. Unauthorized claim of patent rights, of fine up to 500 rupees. Wrongful use of the word patent office, imprisonment up to 6 months. Then failure to supply of information to the central government as controller up to 1,000. Likewise, here some offences and penalties are also recognized under the Act of 1970. Friends, these are the brief things about the patent under the Patent Act in 1974. So, how to what do you mean by patent, and what are the invention qualify for the patent, non-patentability, procedure for obtaining, document to be submit, and grant of patent. After the grant of patent, rights available, limitations, then uh, like suit for damages, infringement. These are the things comes under the Patent Act 1970. So let us move on to the another area of industrial property called trademarks. Trademarks. Friends, a symbol, logo, word, sound, color, design, or other device that is used to identify a business or a product in commerce, it is called as a mark. Mark. Because in India, a Trademarks Act 1999, it extends the protection to the registration of the trademark, provision for the registration of the trademark, and thereby provide a protection for the period of 10 years from the date of registration to such trademarks. Here, trademark is nothing but a symbol, any logo, word, sound. Even sound can be registered as a trademark. Color combination, design, or other devices that is used to identify a business or a product in commerce, because a trademark is a very much essential in order to identify the products, so thereby that product gets a goodwill by using a particular logo or word, by uh, identifying a logo, we are going to say about the goods, a quality of the goods. So that's what here, trademarks are a distinctive marks of authenticity. It is a distinctive marks of authenticity that distinguishes goods and services of a particular merchant from others. Because in a market, the global market, so two or more person producing the same goods are providing the same services, definitely there must be some differences. So differences are distinctiveness is there. So that's what here. So on the basis of the logo or a mark, we are going to identify. We are going to identify the quality or authenticity of that goods. So that's what here. Trademarks are distinctive marks of authenticity that differentiated goods and services of a particular merchant from others. It creates an emotional appeal to products or services, building a valuable brand. Valuable brand. It creates an emotional appeal to products and services, building a valuable brand. Trademark is a valid for 10 years from the date of application, which may be renewed for further period of 10 years on payment of prescribed fee. Every 10 year you are going to renew the trademark registration. So yeah, that's what here the Act of 1999 provides validity for 10 years. Trademark is valid for 10 years from the date of applications. Again, for another 10 years, you may renew it. Then unauthorized parties can use a mark and damage the reputations and businesses. So that's what, because a particular business gained a reputations by using particular logo. So if any unauthorized parties they're going to damage that reputations by infringing that trademark. So that is the one. That's what we are going to protect the trademark. Then registering a trademark protects the business appropriately against a competition. By registering a trademark on one builds a barrier to entry around one's brand. So India also a member of the Madrid Protocol for the international registration of the marks since July 2013. So we are going to extend a trademark at the international level by the Madrid Protection Act. Then what are the legal requirement to register a trademark in India? Here the mark should be capable of being represented graphically, that is in paper form. Remember? Excuse me. So, a legal requirements to
Sir? Yeah.
Ah, yes,
Ah.
madam. Yeah, it's not. 1 minute, madam.
So present slides not visible, sir, now. Now it's okay.
Yeah, am I audible?
Yes.
Yes, madam. Yeah. So, what are the legal requirements to register a trademark?
So some sound
Pardon?
music is going on.
Pardon?
Some music is there.
Madam, I'm not getting you.
Yeah, it's okay, sir. Yeah.
Okay.
Done. Done. Yeah.
The legal requirements to register a trademark here, as per the Trademarks Act 1999 in India, the mark should be capable of being represented graphically. That is, that should be in a paper format. So then only it is qualified to registered as a trademark. Then the mark should be capable of distinguishing the goods or services of one undertaking from those of others. That is another criteria or legal requirements. So each and every mark must be distinctiveness. So distinguishing the goods or services, then the mark should be used or proposed to be used in relation to the goods or services for the purpose of indicating or so as to indicate a connections in the course of trade between the goods or services. Then a mark shall not be, these are the three legal requirements to register a mark as a trademark under the Indian Trademark Act 1999. So then mark shall not be registered as a trademark if it is causes a confusion or deceives the public. So that is the one criteria where where a mark create a confusion in the minds of the people, or where try to deceive the public at large. Then it is not that mark is qualified to be registered as qualified to register as a trademark. Another one where a mark hurts religious susceptibilities of a class of people or a section of the citizen of India, definitely such marks are not capable to register. Then, where such marks comprises or contains scandalous or obscene matters, which is against the morality of the public, definitely those marks are not subject to the registrable. Then if it is any mark is prohibited under the Emblems and Names Act 1950, because there is a one enactment in India, so that is the Emblems and Names Act 1950, which prohibited certain mark to registered as a trademark for the goods and services. So that is the one, legal requirements to register a trademark, and certain marks shall not be registered as a trademark if it is causes some uh, hurts. Then functions of a trademark and advantage of the registration of the trademark. Because so why do we need to register the trademark? Then what are their functions? Of course, once the mark is recognized as a trademark and registered, definitely it identifies the product and its origin, because an individual mark is going to identify a product or a service, and also it tells about the originate, where it is this product is manufactured, produced, the place of origin. So another function of the trademark is that it guarantees its quality, because the people relied upon the trademark of the goods about about its quality. So definitely another function of the trademark is that it guarantees a quality, then it advertises the product. So it will canvas to the people at large about the product, that mark always telling the quality of the goods, and so disseminate to the people at large about the product. Then it creates an image of the product in the mind of the consumer. Definitely it's another function. So where now a Facebook that a trademark, definitely that will create some image in the mind of the consumer. This is the four functions of the trademark. That is, it identifies the product and its origin, guarantees its quality, advertises the product, creates an image of the product in the mind of the consumer. These are the four functions. Then, what are the advantages of the registration of the trademark? Why do we need to register? Of course, it protects your hard-earned goodwill in the business. It will protect the goodwill in the business. It will protect your name, brand name, for being used in same or a similar fashion. It gives your products a status of branded goods. It gives an impression to your customers that a company is selling some standard products or services. An exclusive right to the use of a trademark in relation to the goods or services in respect of which the trademark is registered, to obtain a relief in respect of infringement that is misused by others of trademark. Definitely it is provided. Then power to assign, I mean transfer, and trademark or transfer the trademark to others for consideration. So these are the advantages of the registration of the trademark. Then infringement of the trademark and remedies. Here under section 29 of the Trademarks Act 1999, what do you mean by infringement of trademark? So here again there is a two sort of infringement. One is a direct infringement, another one is indirect infringement. Direct infringement means used by an unauthorized person. So, if any a person who is not authorized to make use of the symbol or a logo or any mark which is registered, if he is using the same mark for his own product or local products, definitely it amounts to a direct infringement of the goods. Identical or deceptively similar mark. So, where not directly using the same mark on his goods or services. So, where identical mark is created or deceptively similar, so where a mark of the a defendant is oftenly confused the end users, definitely there is a deceptive similar mark, then it is a direct infringement. Then registered trademarks are used by someone else directly, the class to the class of goods or services, that is the direct infringement. So direct infringement means where a defendant is unauthorizedly using the any registered trademark is own goods, representing that these goods belong to the same company. And another one where there is an identical or distinctly similar mark is created and making use of that mark which is identical to the registered trademark. So another one, indirect infringement. Unlike direct infringement, there is a no provision in the act that deals with the indirect infringement specifically. This doesn't mean that there is no any liability for indirect infringement. The principle and application of indirect infringement arise from the universal law principle. Definitely, even indirect principles can also be addressed under the act. Then what are the remedies for the indirect, I mean the infringement of the trademark? Trademark Act 1999 provides a both civil law remedy and criminal remedies in case of infringement. In India, here the infringement of the trademark is a cognizable offense, which means the infringer may also face a criminal charges along with the civil charges. So civil remedies are obviously injunction. You may seek the injunction that is a temporary and permanent, and you may seek the damages cost your reputations. Then you may seek the accounts of profits, destruction of the goods using the infringing mark, then cost of the legal proceedings. In case of criminal proceedings, the court dictates the certain punishment like imprisonment for period not less than 6 months that may extend to 3 years. 3 years. A fine that is not less than 50,000 that may extend to 2 lakh. These are the remedies available for the infringement of the trademark. So, friends, let us move on to the another area, another industrial property called designs. Designs, where Designs Act 2000 regulated the designs. Here, industrial designs recognize the creation of a new and original features of the shape, configuration, surface pattern, ornamentations, and composition of lines or colors applied to articles which in the finished state appeal to are judged solely by the eye. That is applied to any article, two-dimensional, three-dimensional by industrial process. That is called as a designs. Here, registered proprietor of the design having an exclusive right to apply the design to article in the class in which the design is registered. It can sue for the even infringement because where exclusive right is given to a person one who I mean registered is industrial design for the certain class of goods. Definitely, he has every right to use that registered design for the class of goods, and if anybody is infringing, definitely you can sue for the infringement. When a proprietor applies for the registration of the design, he shall automatically get copyrights in design for a period of 10 years, which could from the date of registration extended for another 5 years by paying a minimum prescribed fee to the controller, but it should be done before the expiry of that 10 years period. So right to license or sell as a legal property for consideration or royalty, because industrial designs can also it is a transferable. You may issue a license to someone else to exploit it or sell as a legal property for some consideration or royalty. Then artistic works under the Section 2C of the Copyright Act 1957 uh, can't be registered as a designs because certain artistic works are not comes under the designs, because industrial designs always recognize the creation of original features of the shape, configurations or surface pattern, ornamentations and the composition of the lines or colors applied to articles, which in the finished state of appeal are judged solely by the eye. Then, what are the requirements for registration of the design? Of course, it should be novel and original. Your design must be novel, maybe shape or configuration or any lines. It must be new and it must original and novel one. It should be applicable to a functional article. It should be applicable to a functional article. So, to which article you have designed this industrial design? You have created this industrial design. So that is very much important. It should be applicable to a functional article. Then it should be visible on a finished article. It should be visible on a finished article. Then there should be a no prior publication or disclosure of the design. There should not be any prior publication or disclosure of the design. So if an individual qualifies these criteria, definitely his industrial design will be registered under the Designs Act. What it what it does not include, it does not include any mode of construction or any trademark as defined under the class 5 of the subsection 1 of the Trade and Merchandise Marks Act 1958. Then it does not include property mark as defined in the section 491 of the Indian Penal Code. Then it does not include any artistic work as defined in the Copyright Act 1957. These are the exclusion. Then item that cannot be registered as a designs under the Designs Act, signs, emblem, or a flags of any country, they are not a subject matter of industrial designs registrable under the Act. Any signs, size of any article, if changed, structure and buildings, integrated circuits, layout designs, trade variations, any principle or a mode of construction of any article such as labels, tokens, cartoons, cards, etc. They are not cannot be registered as a design. Books, calendars, certificates, jackets, forms, and other documents, greeting cards, maps, and plan cards, postcards, leaflets, stamps, medals, dressmaking pattern. These are not subject to the registration. They cannot be registered as a trade. I mean, design. And mechanical contrivance or workshop alterations of a components of an assembly, part of any article which is not manufactured and sold separately, they are not subject to the registrable. Then piracy of the registered designs. Section 24 of the Designs Act 2000 deals with the piracy of registered designs. According to this section, any obvious or fraudulent imitation of a design, fraudulent imitation of a design which is already registered without the consent of its proprietor is unlawful. It also prohibits the import of any material which closely resembles a registered design. Registered design. This section also provides that in case if a civil suit is brought against any piracy of a design, then the compensation shall not exceed 50,000 for the infringement of one registered design. The compensation is statutorily fixed, so it serves a good ground for interim injection even before. So these are the things about the industrial property at the national level, like patent, uh, trademark, and designs. Friends, if you have any doubt or any comments, please.
I think you can continue, sir. Yeah.
Madam?
Yeah, yeah. No doubts, no? Any,
Okay.
yeah, you can continue. Few more
Tomorrow,
slides, no, sir? Yeah.
let me stop today, madam. Tomorrow I'll continue the 3 and black 3 and 4.
Okay. Yeah, yeah.
Yeah.
Sure.
Okay. Thank you, madam.
So you will finish here, sir, no? Now?
Yeah, yeah.
Okay. Any questions from students?
That's what I'm asking. Any doubts or any questions?
I think no, sir. Fine.
Slides ಕಳ್ಸಿದಾರೆ ಕೊಡೋಣ ಮೇಡಮ್